You're watching from the vantage point of 3 Cobb County deputies who showed up after Sheriff Craig Owens called them to Burger King.
Hey, do me a favor. I need to get, all I need is the owner name or whoever owns this damn facility or the manager.
And the video is grabbing voter attention Friday night.
The video definitely tuned me in.
I don't need no damn money back no more. I just need to find out who owns this place so I can do a physical complaint.
He tells the deputies Burger King staff got his order wrong.
I want to order her a Whopper with no mayo cut in half, right?
3 deputies go to the door.
And they were so concerned that they locked the doors.
Staff give the deputies names, and they bring it out to the sheriff.
That's all I need.
The video is from 2023. Sheriff Craig Owens is running for re-election this year, and his opponent, David Cavender, first posted it online overnight.
I think it is an abuse of power.
Mike Donnellinger is running as chief deputy and called it intimidation and a waste of resources.
Deputies run lights and siren, placing citizens at risk and his deputies at risk just so that he could get information from a business owner that clearly could have been followed upon on another day.
The sheriff called it a business dispute that any citizen can make. He did not respond to 2 requests to go on camera, but in a statement he wrote in part, "I have always worked to build confidence and trust in leadership. To our citizens and residents, it is clear that I need to work harder, and I pledge to do so. Anything that takes away from that mission is a distraction, and for that I am deeply sorry."
If I don't get ketchup on my Whopper, do I get to call police officers with sirens?
The sheriff argues he never told staff his position and power and never asked deputies to do anything they would not do for anyone else.
You didn't tell him who I was.
No, I just told him it was the guy out in the truck.
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that wasn't even, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that, and I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their intention.
Nonetheless, it happened. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right. All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness as a law enforcement officer should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that this jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done. All right. Well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that.
I'm asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
There's nothing more powerful than the odor of mendacity.
All right, welcome back Inside the Law. I'm your host, Philip Holloway. This, of course, being the LawTube channel where we take you inside the real justice system to show you what it's really like from the inside looking out. And, of course, we do this through the lens of the legal news stories that are, in the news every day. So if you thought you knew what it was like from watching the movies or even cable news or whatever, that's not right. We're going to bring it to you the way it really is. And of course, today, I started out with a few more videos than I normally do because we've got a lot to talk about. And I wanted to kind of set the stage. So we're going to talk about the Sheriff Burger King controversy. We're going to get into more of that. We've got a couple of great guests here to help us break down the law enforcement sort of procedure and ethics aspect of that, because there's a bearing in that case to the Fannie Willis versus Young Thug trial that we've been covering here in depth here Inside the Law. But we're also going to be talking about the reason I showed the cabin video. We're going to be talking about Mr. Wade Goes to Washington. Nathan Wade has been in Washington, D.C. recently testifying, albeit behind closed doors, but nevertheless under oath. And I have got myself a copy of his opening statement. So we're going to go through that. And of course, Rachel is going to be joining us. Attorney extraordinaire Rachel Kaufman will be helping us to break down that. And we're going to be analyzing what you think and maybe what other people have had to say also about his opening statement. Now, before I get into all that and bring in our great guests, I wanted to just take a minute. A lot of you have asked, all right, where have you been? Where have I been? Well, I took last weekend off from Inside the Law because I was traveling with my son on fall break. But then, of course, as you know, I still practice law and I have had a very, very busy schedule. But on top of that, I've been involved in some disaster relief flights. And so, there's a lot of people in the southeastern United States that are still suffering and that are still without power, without their homes, maybe even without water, and certainly without the basic necessities of life. So if there are any of you who are in a position, I just wanted to take a minute to encourage all of you to please find a way, if you can, to help those in Florida, in central and eastern Georgia, and of course, North Carolina, and even Tennessee, and perhaps elsewhere. People who still need our help, and it's obvious they're going to be needing some assistance getting everything back together, perhaps for months, probably even for years in some cases. So anyway, that is to answer the question, where have I been? Yesterday, I came in and I was doing some show prep, and I decided to just go ahead and do an impromptu live stream where I shared some of that with the folks who were able to join yesterday. And of course, we looked at the topics that we would be getting into for today. but we're going to be getting a little bit more in depth. Now, before, well, let's just go ahead and bring in our panel that's going to help us. Let's welcome back inside the law your friend and mine, retired Sheriff Scott Berry from the Oconee County Sheriff's Office, and attorney Rachel Kaufman. Welcome, Rachel. How are you today?
I'm good. Hi, guys.
Hey, how you doing, Rachel?
I'm
good. For
good.
the first time ever here inside the law, let's welcome David Cavender. David is a police officer in Cobb County. He's a sergeant, and he is running for the office of sheriff in Cobb County. And that's going to be sort of where we're going to start today. We're going to go ahead and start with this whole thing. And David, you probably saw at the very beginning where I had a news clip. But before we get into letting you help us break this down, I want to share just a little bit more of the video with our audience so that we can get the flavor of sort of what's going on here.
Okay. Well, I'm in a Burger King. I'm by Austell Powder Springs on VMH. I'm gonna go inside and see what I can see. Yes, sir. So downtown, downtown Austell, by the bridge.
Well, I wonder if camera people are doing like some sort of protest.
No, he says it's an 87 with the sheriff and a Burger King employee.
All I need is the owner name or whoever owned this damn facility or the manager.
Okay.
We ordered something, the food was wrong. We said, hey, can we fix it right? The guy said, well, we ordered. I said, that's not what we ordered. What are we doing? I said, well, can I get my no? I said, well, can you give me a manager name or owner name so I can call it? That's all I need.
Okay, sir.
I don't need no damn money back no more. I just need to find out who owned this place so I can do an official complaint to complain.
Okay, sir. Yes, sir.
All right.
All I'm going to do is the sheriff wants the name of the manager or the owner so he can file a complaint. That's all. How are you? You a manager or assistant manager?
I'm the assistant.
Okay, is the manager here?
Yeah, I mean, I'm the assistant manager.
Yeah, but is the manager...
The GM is not here, no.
Okay. Nobody's in trouble. We just want to get some names, and then we'll be out of here, okay?
That's fine.
All right. So what's your name, please?
My name's Blaine.
Huh?
BLA. IYN.
IYN?
Yes, sir.
And your last name?
For right now, I'd like to keep it at that, just because my interaction with Cobb County so far is
there's going to be no interaction with Cobb County at all. There isn't even going to be a report written.
Okay, before we finish this video, I want to point out what you just heard. There's not even going to be a report written. Okay, so we're going to come back to that. Let's finish it out.
I get that.
Okay, the guy out there, he's just going to file a complaint for his food.
And that's totally fine.
That's all.
But past that, I'm not giving out information just because I've had people stalk me for months, pull out guns, try to kill me. This area is not a great place to work. I don't give out my personal information to keep me safe. When I tell you I've had people follow me home, follow my truck, they followed me around here for 2 months. And the last time I talked to Cobb with it, not you guys, not the Sheriff's Department, but regular Cobb County Police told me to stop calling. You guys were providing a service, so respectfully, my opinion, and working with the police in the past couple months has shot way down. So I'd like to keep it at that for right now.
Are you worried about that guy?
That guy or whoever. I mean, I've had people follow us. We've about probably 4 days ago.
What's the manager's name? And she's the manager?
That's correct.
Do you know who the general manager is or who owns the place?
That's the general manager. GPS Hospitality owns the store.
So who owns it?
GPS Hospitality.
Okay. And do you have Karen's phone number?
Yeah, it's going to be 2.
All right. Well, that was all I needed. Thank you for your time.
Have a good one.
Have a good day. It's an assistant manager working right now. He didn't want to give his last name, but his name was Blaine.
Did we get the manager's name?
Yeah, the manager is Karen.
Okay.
And the people that own this place is GPS Hospitality.
Okay, that's all I needed.
All right, sir.
Appreciate you, man.
Yep, no problem. Have a good day, sir.
And he didn't want to give me his information. Huh?
All he wanted to give me was his
That's
first name.
the white male with the mustache?
Yes.
Okay.
Yeah, he said he felt threatened that somebody was going to do something to him, so, like stalk him or something. It didn't help none.
You didn't tell him who I was?
No, I just told him it was the guy out in the truck. Okay. So I wouldn't tell him who he was. I just left
absolutely. Ask Mike, I want to order her a Whopper with no mayo cut in half, right? Mm-hmm. So we get the mayo half.
All right. So that's sort of a synopsis, and we've got a little bit more different body camera video that I'm going to be sharing. But Rachel, I want to go to you first. You're not a police officer. You never have been, as far as I know, but you've been involved in the criminal justice system. And as a lawyer, you look at body cam videos and things like this all the time. So I want you to tell us what your thoughts are about what you saw. But before you do that, help link up for anybody who might be new here inside the law, link up why this story about the Cobb County Sheriff is relevant to the YSL trial, which is what you and I talk about so much.
Okay, so hi everybody. Happy Sunday. We're talking about the Cobb Sheriff, because the Cobb Sheriff's office is responsible for housing several of the defendants from the YSL trial that's going on in Fulton in their jail. There's been a lot of issues in their jail ever since they've taken on a lot of the Fulton County inmates. But it's clear that their leadership is spending time trying to investigate the manager's name at a Burger King. As a person who is not in law enforcement, the only thing, and somebody who was a teenager when Super Troopers came out, I'm sorry, the only thing I think of is Farva wanting a goddamn liter of cola, and he's screaming at the people at the fast food place. I mean, that's basically what's happening here. I'm a little confused about how is that the actual sheriff?
Yes.
Yep.
I mean, what a disgusting display and abuse of power. And I wish he didn't clip his dog's ears, because I think that's abusive. Those are my few thoughts. I like his dog breed, but I'm not into the way that he treats his dogs. Or, I mean, why didn't he just go in there and ask nicely? Why does he have to bring law enforcement into it? Gross.
All right. Well, that's a great question. So I want to get to David, but before I do that, Scott Berry, retired sheriff, many decades as an elected sheriff yourself, and a deputy sheriff before that. And I think you might have even been in the Pinkerton Guards back in the day.
We used muzzle loaders back in my day.
So have you ever had to call your deputies to assist you with your Whopper?
No. And I'm embarrassed. When I first saw this, a month ago or whenever it came out, I rolled my eyes just as I am now, because I've never seen a sheriff even act like that before. Cobb County has a history of great men being sheriffs. Bill Hudson, who's sadly dead now, Neil Warren, and now they got this clown. I can't excuse this behavior. This is. I mean, he got his deputies running code 3 to a no mayonnaise call. Seriously.
Well, I mean,
I don't even know what to say.
Well, all right. So we're going to come back to you, Sheriff. But David, I'm going to let you explain to everybody what code 3 means, and talk to us about the driving that we saw, and why a law enforcement officer might need to drive in such a fashion.
Hey, thank you, Philip. Yeah. Code 3 generally is, is an emergency response for like real emergencies where someone's life may be in danger, or something of that nature, someone kicking in the front door, not generally because the senior law enforcement official in the county can't manage to order a fast food meal correctly.
Well, I mean, so.
I mean, what are they going to do when they get there? Okay, the sheriff.
I don't even think they knew what they were going to be honest with you.
No, I don't think they did either. I don't think they'd have driven like that if they knew this was a no mayonnaise call. Okay.
Well, so I think it bears fleshing out, David. So was this something first off, you are running for the office of sheriff, and I know that this story originated because I think you guys put it out on your Facebook page after somehow you got wind of it in the last month or so. And what do you know about how this situation unfolded? Did he call 911, or how did the deputies wind up getting involved? Because for those of you who don't know, Cobb County, the sheriff's office there, of course, they are full law enforcement officers, but they are not technically a full service sheriff's office. There is a county police department. You have a car crash, you're going to call 911. Cobb Police generally is going to respond. You have a home invasion, you have a burglary in progress, you have shoplifting, you have a general business dispute. You call the police in Cobb County. The police department is going to show up. The sheriff's office is constitutionally mandated to do a number of things, including the courts and security and run the jail, as Rachel mentioned. And they have full law enforcement authority. I'm not saying that they don't, but it's just not the kind of thing, David, I don't think the sheriff's office would normally respond to if it were a business dispute. So how did this whole thing unfold?
Yeah, so to the best of my knowledge, I believe the sheriff called someone on his cell phone, called back to his own agency to have people sent out there. I did obtain the 911 open records with the recorded lines, and as you kind of listen through some of that, you hear one of the supervisors key up and ask some deputies for their locations, and then he told one specifically to head towards downtown Austell, and that he would call him on his phone with further information. So they didn't even want to put it over the radio. So as far as the deputies running lights and sirens, I can only have to imagine that they were acting more in good faith than anything else, and hopefully they just didn't know they were going to.
The goal was to. The goal is to like intimidate the people that work at Burger King and make their food. And again, if they didn't watch the rest of Super Troopers, it gets worse for the troopers because then they start like spitting in their food and stuff. So you just got to be nice to people that are making your food, period.
Hey, and that's a great statement. I've been saying that the whole time. Like the way you treat people matters, because quite honestly, I didn't even know this incident ever happened. And I've had people accuse me of holding on to this and releasing it right before election start. And I sent you, Phil, a screenshot of the open records timeline. So I didn't even find out about this till early September, and requested on September 8th and got the videos on the 24th. And when I watched them, I was honestly in shock that it was a real event. I really didn't think it happened. And so from that point on, it took about a week and a half or 2 weeks to get it ready to put up. But I think, like you said, too, the kid that was working there, Blaine, talks about how they have all kinds of interactions with employees and how dangerous of an area it is. So to just keep that in mind when you realize like the doors to that Burger King were locked because of the sheriff.
They locked the doors. There's no telling what happened before those deputies with body cams got there.
There really isn't. But to touch on your original question about if someone had called the police, because we do get those calls where someone calls the police because a car wash scratches their car, or they didn't get enough change back at the gas station, or whatever it is. The police arrive in Cobb County, and should the police have shown up to that, they would probably ask the employees, hey, what actually happened in here? Instead of saying, hey, don't worry about us. There's nothing to see here. We need some names and we're leaving.
Sheriff Barry, if one of your deputies were running what we call Code 3 with lights and sirens, and of course acting as an emergency vehicle, and of course they're if they're authorized to run in that fashion, then the law says that they can run stop signs and red lights, and any other traffic laws are essentially suspended. But what happens if maybe there had been a car crash, and let's say some third party, a citizen or a deputy or anybody else, had been injured because of this driving in this way under these circumstances?
Phil, you know exactly what happens. The sheriff's office.
Asking you.
The sheriff's office would be sued successfully, okay? Because when you look into the background, can you imagine being the lawyer in that case?
I'd be happy to do it.
Oh, I know it. I know. Of course you would. You would get you and your client would get a paycheck. There's no question about that. There's no excuse for particularly driving like that. for somebody got mayonnaise on their hamburger,
I
or
want to
wasn't cut in half. Whichever.
Speaking of driving, before we, I don't want to kick a dead horse, but I want to just show a little bit more of the response here.
I think there's more to the Whopper side.
I mean, this goes on for about 10 minutes. I mean, it's more of the same, but that's, you can hear the siren. It sounds like a seatbelt chime, like a seatbelt's coming off. I mean, and I just, I'm looking at this and I'm just, the older I get, the more, I guess, I'm aware of my own mortality. I tend to drive slower and do things.
Yeah.
But I see that and I'm just thinking, I'm sure it's the middle of the day. I saw shopping centers. I couldn't see the speedometer, but it looked to me to be like a very high rate of speed. I know I heard a siren, and I'm sure there were blue lights that were flashing, right?
Well,
So,
Phil, to give the deputy he's not here to defend himself, but my guess he was told the sheriff needs backup at
right.
Okay, as you hear, as a deputy, I'm a deputy sheriff now. My sheriff needs backup. I'm going.
Correct.
I'm going to get there, and but again.
Oh yeah, I mean that's if it comes across the radio or it comes across as even an officer needs backup, let alone your boss.
Right.
I mean,
right.
Of course, and that's why I'm glad David pointed this out, and as you did, and I concur. The deputies, by all accounts, and from what it appears, there's no evidence to the contrary. They seem to be acting in good faith.
Right.
But I feel like that I don't know if there were, let's just say, any litigation that may have come from this, should someone have been hurt, I'm sure the sheriff would have been in the hot seat himself for putting them in that position.
Absolutely. Absolutely. And of course, when the sheriff gets in the hot seat, the taxpayers get in the hot seat because that's the way the world works.
It's all at the taxpayer's expense. I mean, the fact that the deputies are showing up, speeding down the road, doing all that stuff, that's all at the expense of taxpayers. And then having deputies take time away from protecting and serving the community to go deal with this very minor, ridiculous issue at Burger King for their sheriff. That's more tax dollars. And and then if somebody were to have gotten injured during it, who's going to pay for all of that? Where does that settlement come from? Taxpayers. It's crazy.
You notice he didn't want the employees to know who he was. At the end, you didn't tell them who it was, did you? Some words to that effect.
Well, you know what's funny? The general manager actually emailed me to campaign email after this video aired on the 11th, I believe, over the weekend, last week, and he emailed me, and he said, absolutely, the sheriff did tell them who he was inside the store.
I would believe.
I believe that. Yeah,
me too.
I believe that.
Well,
look,
it's just the reason I stopped and I pointed out where the responding deputy says, look, there's not even going to be a report written about this. It suggests to me that maybe once he arrived and realized what he had on the scene, maybe he was. I'm sure it was an uncomfortable situation to go into that business where they had locked the doors and say, hey, look, I just need the name of your manager and a phone number so the guy out there, without identifying the guy out there, can make a complaint about a Whopper. So,
Phil, while we were watching this, it occurred to me, what would have happened, and I know this is hypothetical and we can beat that horse to death, but what would happen if the guy left the door locked and told you, I ain't telling you my name?
Yeah.
Mm-hmm.
I mean, no crimes have been committed. I mean, there's maybe eating at Burger King, but
Now, wait a minute. Hold on. All right. Well, David,
that was supposed to be a joke, Rachel.
It's very funny. I mean, I like that. It's really hard when an officer asks you a question like, "What's your full name?" It takes a lot. It takes a lot of nerve, but in a positive way here, to not give him your full name. I respect the guy for saying, I'm not trying to do that today.
I do too. I respect that guy for saying, nah, I ain't doing it.
I'll pass. Yeah.
David, somebody was asking, how often do Cobb police, let's say, respond to business disputes? And the follow-up question that I want you to think about answering is, when they do, would you even respond to someone who calls and says they didn't put mayonnaise on my Whopper?
Yeah. So the first part of the question, yes, we do. We get business disputes all the time, man. Yeah. If the business calls in and says they have an irate customer and they're over something, then of course we're gonna get there as quick as we can. We're not gonna run lights and sirens unless it, of course, becomes something much more of an emergency nature. But if someone called and dispatch tried to send my officers to Burger King because someone complained that they're about the condiments on their burger, I would absolutely cancel that call, and we're not going. But to take it a step further, when we do show up on business disputes, we'll actually ask the employees there what happened, and
what happened,
and then we'll write a report, and we issue criminal trespass warnings on behalf of businesses all the time. So it's likely if the police showed up, there would have been a report written, and the sheriff would have probably been told he's criminally trespassed from Burger King from now on.
Yeah.
This is a good question that popped up for you, Scott. If you got a call that the sheriff needs backup and you hauled behind to the location and the sheriff said he had a burger complaint, what would you do as a responding deputy? Let's see, you're retired now, and so you speak the truth.
I don't, but I'll be honest with you. You got to question the leadership of a man that would ask you to do that. And quite frankly, I'd lose all respect for that man. I seriously, mayonnaise sheriff. I mean, at my age now, I would say those kinds of things. When I was a young deputy sheriff, I don't know what I've done, but you lose all respect for that man. All respect for that man.
I feel bad. Is he married? Because I feel bad for his wife. God forbid.
Well, apparently, he was ordering the burger for
his wife.
For the wife, yes.
Well, God forbid
she doesn't like mayonnaise, apparently. Huh?
I mean, I said, God forbid she doesn't. Mimi says too. God forbid she doesn't cook something right. I mean,
well, he said something to one of the local news that to the effect of his wife has an allergy or something to the mayonnaise, and but that's really, I think, neither here nor there. I think it's just the whole thing to me. It strikes me as just a very bizarre. I don't even know how to describe it, guys, because I've been in and around law enforcement since 1988, and I have never seen anything like it.
As far as him saying that his wife had an allergy, it took him 3 days to make that statement, and he also said at the end of that statement he actually gave the burger to a homeless person. So it took him from Friday to Monday afternoon to figure out what he actually did there and make a statement to WSB.
Yeah, what kind of allergy? I've never heard of such things. But,
I don't know.
Okay.
Well, anyway, David, thank you for hanging out with us on part of your Sunday afternoon, and getting in, and helping locate those videos and helping me understand sort of the context. One last question before you go. I had about was there any traffic, like radio traffic over the out of the 911 center or out of the official dispatch, or was this all over the phone?
There was it was a little bit over the 911 recorded line, and it caught, like I said, one of the supervisors asking a few deputies for their locations, and when one was close, he told them to start going towards downtown Austell, and he would call them with further information. And then, if you listen in some of the videos, you'll hear him. You'll hear the call sign 101 key up, and that's actually the sheriff himself. And then someone responds and says, "There's 3 en route to you," and then he says, I believe something along the lines of, "He's code 4, but continue 1," and then no, continue 2, but he's code 4, which should mean he's okay. But yeah, I feel like most of the pertinent information that was relayed over cell phone.
All right. Well, look, man, I appreciate you spending some time with us on a Sunday here inside the law, and of course, you're welcome back anytime. Thanks again, and hope you enjoy the rest of your Sunday, bud.
Absolutely. Thank you for having me. Nice to meet you, Rachel. You, Sheriff.
See you later, David.
All right. Well, look, guys, I thought that was just a very interesting, an interesting topic for us to get off with here. It's not it's not a criminal court case, but it is related, of course. And the sheriff's office has been in the news. They've been in the news. We did something here recently about, there was some jail deaths involving 2 inmates that were being housed on behalf of Fulton County in Cobb County. And so that's been something that we've talked about. And of course, Young Thug is being housed along with other inmates in the Cobb County jail that is under the purview of the Cobb County Sheriff and the Sheriff's Office. So that's why it was, I think, relevant to the show. And of course, we will talk about law enforcement issues, anything related to the criminal justice system. We're going to get into that here inside the law when it makes the news. And so that did. And here we are. But now I want to switch gears because let's see, let's just go ahead and want to add to the screen here. Let's see. We've got Rachel. I want to get into some of the YSL stuff. We've got here we go. We've got Nathan Wade. Before we get into the YSL per se, we're going to segue into that through the Nathan Wade thing. He recently was subpoenaed to testify in Congress, right? And so I posted on X the other day, looks like Willis might be getting nervous. She sent this was posted by the House Judiciary GOP on October the 11th. Willis sent Mr. Wade this letter. She says she's writing in her official capacity as DA and on behalf of her office regarding a recent subpoena he received from the House Judiciary Committee. She goes on to say, "I remind you of your continuing obligation not to disclose any confidential information related to ongoing criminal matters on which you worked. As the special counsel of our investigation into unlawful interference in the 2020 presidential election, you have knowledge of highly sensitive and confidential information." And she goes on to say, "I am concerned that questions posed to you by the committee could implicate several established privileges and confidentiality interests. This includes preservation of the, evidence." And she talks about the committee's demand for your testimony would require you to divulge confidential and privileged information. We previously asked the committee to withdraw its demand. So, Rachel, first question that comes to my mind, there are certain things like, attorney work product. That is a confidentiality type privilege, if you will, that lawyers, enjoy. You can't be required to disclose, like, to the other side, like what the fruits of your efforts as an attorney on behalf of a client. But if you're a prosecutor, you don't really have a client, do you, Rachel? You have just the general interests of society, I guess, but you don't have a client. So, Rachel, what privileges do you think Willis could be trying to protect here?
I mean, I don't think that there's anything about what they would be asking him that is privileged. I mean, there's like an attorney-client privilege. I guess it's protecting the integrity of the investigation, except we're at the point where these individuals have been indicted and discovery has been provided, and those things are not private. It actually is shocking to me that she sent this letter knowing that Nathan Wade has been traveling around giving interviews to basically anyone who will listen to him, making jokes about his relationship with her, answering tons of questions from tons of different media outlets. And so now all of a sudden, when, the House wants to look into, the nature of the prosecution and where the money came from, what they used it for, none of that is privileged information. And so this is a whole lot of legal bullshit. Sorry. But I mean, I don't even, it's hard. Yeah, I'm not really even sure. I mean, you can say a lot of words, but it actually, and I've said this before, is her efforts to try and avoid providing information and the lack of transparency demonstrate that there is something underneath it all that they need to be getting, that needs to come out, because most elected officials who have nothing to hide will not go to these bizarre lengths to try to hide it.
Phil, I'm going to take this moment to split. I'm going to run. Rachel, I love you. We'll see you later. Phil, good
All right,
job.
Sheriff, we appreciate you hanging out with us here inside the law. Anytime, you're always welcome, my friend. Thank you.
Thank you, brother.
Big round of applause for Sheriff. Thanks so much, my friend.
Yeah, so this is just embarrassing. And I told everybody, I think a few times ago, to go watch the Daily Show. Marlon Wayans does an interview with Nathan Wade. How dare she now come back and say, try to claim that there's some kind of privilege where he's not allowed to get on screen and talk about it. He's probably made a lot of money off of those interviews. So,
well, look, let's look how what we have here. We have, I also posted, by the way, you can find all this on my X feed. This is from October 15th. I said this is per a source with direct knowledge. Former Georgia Governor Roy Barnes is in the room for the Nathan Wade congressional deposition regarding the Fannie Willis. Barnes represents Willis. And as I said here, he sent this, I call it a wackadoo letter because I think it's just wacky, to Chairman Jim Jordan and the Oversight Committee. This is the former governor, of the state of Georgia, who has been seen in the Senate, the Georgia Senate chamber, when they've been holding hearings related to this issue. He says, Mr. Chairman, I reviewed your letter of September 21st addressed to Nathan Wade. Now, he doesn't represent Nathan Wade, but he's reviewed this letter. It says, though my client and I were discussed in the letter, I was not sent a copy. Well, first off, I don't know any reason why he would have been obligated to send Governor Barnes or his client a copy. But anyway, it says, I obtained it through public sources. Fine and good. But he goes on to say, I find the tone of your letter to be filled with vitriol and anger. I would suggest you take some deep breaths and calm down so this matter may be discussed without emotion. And get this. He says, an anger management might also help.
Shame
Rachel,
on you.
have you ever, would you write a letter like this?
No, who do you think you are? I don't understand. And then he goes, I'm just a country lawyer. Well, if you're just a country lawyer, then you're not a therapist. You have no business telling me what I need to do. I'm asking for information, cut the bullshit, and just answer the questions. And you're not even his lawyer. So what are you writing me for? No one was talking to you. Just a country lawyer. What?
Well, and so, yeah, the letter goes on to say, I'm just a country lawyer, unaware of the ways of Washington, D.C., but I must comment on your statement. So, I guess, I don't know what he means by being a country lawyer. I've seen his very large, nice house in
the former governor.
It's in Marietta, Georgia. It's not really a secret where it is, and I wouldn't call it a country estate. I certainly wouldn't call it a farm. But maybe that was his roots. But I wouldn't call him a country lawyer. But look, I guess he can call himself one.
Quoting the Bible. Oh my God. Here we go.
Yeah. So, listen to this. He goes on to why he says, when you have calmed down and attended anger management class, I will be glad to discuss this matter with you in a logical, dispassionate manner. I mean,
out of control. This guy's out of control. And this is the problem. Okay. As an attorney, and people always ask you, there's like this relationship between a client and an attorney. And I think that even though that clients do kind of direct a lot of what you do and how you do it, there's a place where the attorney has to look at the client, in this case, Fonnie Willis, and say, this is not appropriate. And no, we are not going to do this. You have to be the captain of the ship ultimately as the attorney trying to represent your client. I can't imagine that he came up with wanting to do this himself, but he's just kind of letting his client run the show here. For him to be sending a letter like that, you say you're a country lawyer. Again, I realize he's not really a country lawyer, but he's kind of feigning like, I'm ignorant to what you guys do in DC, but I'm going to tell you exactly what you need to do before you talk to me. It's like, no, we subpoenaed Nathan Wade and he's going to come in and he's going to answer questions. Who's out of control here?
Well, I can't understand why he's allowed in the room. He doesn't represent the witness, Nathan Wade. But look, so Fletch, thank you for the super chat, by the way. Those things get flagged and I can see them. I see the chat is very, very busy. These things catch my eye. So I wanted to go ahead and mention it. Thank you for the super chat, by the way, Fletch. Shout out to the late, great Phil Hartman, unfrozen caveman lawyer on Saturday Night Live. I was actually trying to think of that character's name as Rachel was talking. And then Fletch, you happened to just come through like it was ESP or something when you got the information for me. But yeah, that's exactly what I thought of too. Rachel, that might be before your time. You're younger than me, but anyway, that's exactly what came to my mind here.
He was a former governor, correct? Roy Barnes?
Yes. Yep. And I think when you're the governor, you have a lot of interactions with DC. You have interactions with the White House, with Congress, and state, or executive agencies, all kinds of things. I found that to be not very persuasive personally. But,
and again, nothing was addressed to him. Correct? Yeah, he's talking about anger management. It's like, I'm not even talking to you.
Correct. And I think that may be why my source sent it to me, because they kind of found it that was, I don't know, a bit unusual. But here we've got, I posted Nathan Wade's opening statement from his congressional deposition regarding the Fonnie Willis fiasco. And if you want to see it, I posted it on October the 16th. And it goes on to, I'm just going to hit the highlights, but he says who he is. He's a licensed attorney. He goes on to say that prior to accepting the appointment as special assistant district attorney for the office of the district attorney of Fulton County, and I don't even know that he ever was he. I don't know what this designation of special assistant DA is. I always thought it was special prosecutor, but anyway, it's a distinction maybe without a difference. But he goes on to say that he served as a prosecutor several times during my career. Rachel, he says, first as an assistant solicitor general in Cobb County, Georgia, which of course is next door to Fulton, and then as a special assistant attorney general for the state of Georgia. We would call that a SAG, S-A-A-G. Rachel, describe for those who may not be aware what an assistant solicitor general in the state of Georgia does.
They prosecute misdemeanor offenses, meaning offenses that carry less than 12 months imprisonment maximum. So we're talking the most serious stuff that he'd be trying are DUIs and batteries, like family violence battery cases, but mostly traffic tickets.
Okay.
It's no disrespect to assistant solicitor generals, but the way that he this entire opening statement is a bizarre puffing of sorts, inflating his credentials and inflating, his accolades, and it's just embarrassing.
Well, they don't prosecute RICO cases, right? I mean,
Sure don't.
I think the most complicated cases that you'll see as a misdemeanor prosecutor might be like a DUI or, maybe a misdemeanor vehicular homicide, although those are usually not even complicated. But they certainly aren't technical, right? So, I guess it's just, like I say, it might be inflating or puffing a little bit, but I want to ask you, Rachel, have you ever seen in the state of Georgia a special assistant attorney general that was actually a prosecutor?
Okay, so the only context that I have for anybody in the attorney general's office prosecuting is this Cop City case. I don't know if they're called a special assistant attorney.
I'll help you out. They are not. They are lawyers that are full-time prosecutors working in the criminal division of the AG's office.
Yeah, I know them.
Yeah.
Yeah.
All right. So
he's not one of them.
Okay. So he's not one of those. Well, look,
Right?
let me skip ahead. Okay. Because there's a lawyer. Here's what I posted. I said, I will add this, even though I said I wasn't going to fact check. I said, in my experience practicing law since 1996, these are not considered prosecutors. They are private lawyers contracted to handle certain matters, often civil matters such as child welfare cases in juvenile court. And I did a screenshot right off the Georgia Attorney General's website. And it says here that's exactly what SAGs are typically retained to handle cases. They're outside attorneys. They are hired on a contract basis. So they're not like full-time employees. They don't have benefits and they don't have the badge and all that stuff that attorneys general or special or assistant AGs have. But it says they are outside attorneys retained to handle cases where the AG's office has insufficient staff attorneys to handle the caseload. In cases where it will be inefficient to send staff attorneys to hearings, such as for child support or deprivation, that's a juvenile kind of case like child deprivation, because those cases are heard in all 159 counties throughout the state of Georgia, and the Attorney General doesn't have offices in 159 counties, so they outsource these things. Okay, and where criminal prosecutions might need to take place in some outlying county, you've got a local district attorney there. Okay. You don't always have the attorney general. They don't really often step out and actually handle indictments. They can, but they leave 99% of that to the district attorneys throughout the state. But they are obligated to handle these types of special things related to children and cases in juvenile courts throughout the state. They're obligated to do that. So when they can't send their regular AGs there, they hire outside attorneys to do them. So I certainly would not, in my opinion, call them prosecutors. And there's a lawyer that you might have heard of. Her name is Ashley Merchant, and she weighed in on this tweet as well. And she gives a link to, I think it's the same page where I screenshotted. She says that this particular page lists every attorney who was actually a special assistant attorney general for years 2010 through 2023. Guess who isn't listed, she says. So if he was a SAG, it had to be pre-2010. I'm sure an open records request would clear it up.
And she's the open records request queen. So if anyone's going to find it, it's going to be Ashley.
Yeah.
Wait, can we go back to his odor of mendacity? Because he does mention something absolutely ridiculous.
Oh yeah. I kind of skipped ahead because I was going through it. And so like he talks about the SAG and all that. Then he talks about private practice, where he's represented hundreds of individuals in state and federal courts. Okay, fine. That's typical for anybody in private practice, although I would think I've been involved in thousands of cases. It has to be thousands of cases. But anyway, I have served as a civil attorney. He's been retained to represent a Republican sheriff as well as the legal counsel to the Cobb County NAACP. And then, Rachel, we're going to get to the mendacity thing, but let's talk about this. He talks about serving as a municipal court judge in several cities. He was proud to have become the first African American to do so in the city of Marietta, Georgia. So, look, Rachel, you know as well as I do, and this, I don't mean any disrespect to any municipal court personnel that may ever see or hear this or may be watching now. Municipal courts in the state of Georgia exist for one purpose and only one purpose, and that is to raise money for the city, primarily through traffic offenses. So this is a traffic court, and to my knowledge, Rachel, first off, he was never the chief judge in Marietta. I know that for a fact. He was one of several associate judges, and even the chief judge, who's the one that's primarily there, it's only a part-time gig for that person. During the time that he was serving as an associate municipal court judge, the full-time guy had been there a long time. This is a court that I was practicing in, so I got firsthand knowledge of this. And that guy, he was a full-time criminal defense lawyer. So his part-time gig was as the municipal court judge. And when he couldn't be there, they would bring in one of the associate judges to sort of rotate through. So that's how it really works in the real world. So if you just lay this sentence out there that, I was proud to be the first African American to be a municipal court judge in Marietta, you've got to understand what the context is. And so if you just were to read this, it's almost like somebody's telling you they've got this vast judicial experience when in fact it might be something very different from what maybe is conjured up in your mind's eye. Rachel?
Yeah. So in municipal courts, there are no jury trials. So he definitely never, was involved as a judge on the bench, presiding over any sort of jury trials or anything other than, I guess, misdemeanors. It's an important job to have municipal judges given, the amount of tickets and stuff that go through municipalities. But at the same time, to add that as if, I don't know how that's even relevant to what they're asking him, but he probably served on the bench less than 10 times, I would imagine. I mean, it wasn't like a regular position where he was sitting on the bench. He's the king of getting these cushy, contract jobs where he just kind of gets to show up and do less than a real employee would do and just get paid. He's really good at that. Amazing.
Well, all right. So to your point, here we have on the next page, he talks about the background into the indictment and all this, but then he talks about what we're all interested in. We're interested in the disqualification issue, right? Not the guilt or innocence of anybody and all that. I'll leave political pundits to talk about that. But he talks about the trial court held a hearing during which I testified and was cross-examined. And that's some of the video that I played at the very beginning of the show. But then he goes on to say in its distasteful dicta, D-I-C-T-A, dicta, by the way, is a legal term describing something that may show up in a court's opinion that it's irrelevant to the actual holding. But so he says that the judge said that he says the court opined that I either resign or the DA's office resigned from the prosecution. Consequently, I voluntarily submitted my resignation immediately. Right. So was that what you were talking about where he referred to the court's dicta?
Yeah. Distasteful dicta.
I mean,
I could make jokes. I'm not going to make jokes, but I'm just saying that is, it's disrespectful to the court and to what the ruling was. And it's dicta to the extent that it was it wasn't the actual ruling itself, but the basis for the ruling is the dicta he's talking about. And that's the fact that the interaction between Fonnie Willis and Nathan Wade created an odor of mendacity, meaning it appeared that without, I would have called it other things, maybe like perjury, which we're going to talk about in a little bit, I'm sure.
There's nothing more powerful than the odor of mendacity.
Yeah, so it's disrespectful to what the judge found, calling it distasteful dicta. No, it's actually him coming to a conclusion based on your lies. So that's how you ended up having to resign. I voluntarily submitted your resignation immediately. Distasteful or not, It's what it's how courts rule. I mean, the thing with these prosecutors, it's as though, and it's true, they're not used to not getting what they want, and so when they don't get what they want, they throw fits, just like this, and it's disrespectful to Scott McAfee, who, in my opinion, has done an amazing job managing this, that incredibly ridiculous RICO case.
Well, he says here, I am here to cooperate, and he welcomes all legal and relevant inquiries related to your defined scope. Contrary to any fabricated story that I somehow evaded service of process, I voluntarily reached out to the U.S. Marshal's Office and suggested a meeting place and time. Immediately upon being made aware through false and inflammatory media reports, Congress attempts to serve me. Well, look, I mean, I wasn't there. I don't know all the ins and outs. We just know what was been reported. This is what Wade says about it. Other people may have seen it another way, but in any event, he says he's there, fully ready to cooperate. Rachel, what do you think?
Usually you don't voluntarily reach out to the U.S. Marshal's Office unless it's gotten to the point where the people that are trying to subpoena you can't reach you and you're AWOL. So it was the false and inflammatory media reports that caused you to voluntarily reach out to the U.S. Marshal's Office and actually set up this interview, which you had agreed to previously and then dodged for several months.
All right. So here at Inside the Law, we were able to sneak a camera inside the deposition room. And let me just show you a little clip of what happened.
I'm asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
You've never gone to a cabin with Miss Willis?
No.
Have you ever gone to Tennessee with Miss Willis?
Yes.
So look, I've never timed that, Rachel, and I don't know if you have, or maybe if anybody in the chat has timed that, like how long he paused waiting to answer whether he's ever booked a cabin. Maybe when the judge listened to and observed that kind of testimony, maybe that's why the judge felt that there was an odor of mendacity, because maybe it just didn't come across as truthful.
Yeah, and then it makes me think about how he would bill for like 24 hours in a row. And it's, I guess, if you're thinking at that speed, it might take 24 hours.
Okay. All right. Well, look, so he went on to, I'm told that maybe in a few days, hopefully we may even have a transcript of his actual testimony in there, and we'll see what he was able to say and what he maybe refused to say, and whether or not there was any odor of mendacity left behind when they left that hearing room. Now, Rachel, we got to move on to YSL, and we can do this in any way that you want, but look, there's one thing with YSL that we've got going on. You had this week, okay, you had an assistant district attorney, right, by the name of Sprinkle, deputy DA. I'm sorry, I should have called him by anyway, it's a lawyer working for Willis's office who is testifying. And to me, it felt like a conflict of interest, because if a lawyer cannot be the rule is you can't be a lawyer and a witness in the same case. And so I wonder why that rule doesn't apply here, because all the lawyers in the DA's office, it's like a law firm, except it's public. They all get their power to prosecute it flows directly from the elected DA. It's delegated to them by the district attorney, and without the district attorney, they have no power. So it's almost like they are essentially all the same lawyer, or at least their power to prosecute all comes from the same source. So I don't understand why the rules would be any different. I have never, ever in my career seen a case or been a part of a trial where they would call another prosecutor as a fact witness in front of a jury. Rachel, what's going on?
This is Fulton County, babe. I've been involved in many cases where they've used their own prosecutors as gang experts, as cell phone experts. I mean, deputies sprinkle. I guess this is not a rare occurrence in Fulton County. Do I agree with you that it seems like a conflict of interest and bizarre that it's allowed? Absolutely. And then this isn't the first time that he testified. He's been on the stand before. And so it's shocking that they're calling him back to continue wasting the jurors' time.
So like I guess they're saying, okay, well, he's some kind of, investigative prosecutor. They've got their own in-house police department. Essentially, they have criminal investigators with badges and guns and arrest powers and all this stuff working at the DA's office. You see these people out working part-time jobs at the Atlanta Falcons games and other things like that as full-fledged law enforcement officers, which they are, but they work for the district attorney. And so
it's inappropriate. I mean, it's the whole way that the Fulton County DA's office operates. I hate to say it, but it's just the truth, is that the rules don't apply to them. They don't understand conflict of interests as it relates to the way that they prosecute cases. I mean, I'm hopeful that the jurors are like, this guy works for your office. Why do we care? He also, I mean, I've known Mike Sprinkle for years. He basically is like this. He does all the preliminary hearings for homicide cases, and he's been doing this forever. The amount of if there's like, let's say 250, that's a conservative number of homicides that are handled in Fulton County every year. He doesn't remember 2015, but he's being prepped by his own office. Luckily for the defense in this case, I do believe, as annoying as he may be on the stand, that he is not going to lie in the way that some of these other prosecutors lie. So is he an honorable guy? I'm seeing True Stories asking, I prefer him and his ethics. I like him more than I like a lot of these other prosecutors. And I think that his job is so separate from what they do. I mean, they're asking him questions about times. He's like, I don't know, this was 2016. So he's doing his best, but calling him to the stand, I don't even know. I mean, I watched some of it and I have no idea oh yeah, this is fun. We'll talk about this.
Well,
next.
somebody's asking in the chat, and I noticed that someone also asked it on X, where has Love been? And is Adam Abadi now taking over as the lead? Rachel, what's the skinny on that?
Okay, so my understanding is that Adam Abadi's taking over as first chair. He was also the attorney involved in the Trump RICO case and basically represented Fani Willis. This all kind of comes on the heels of Fani Willis writing some kind of email to the prosecutor to the judge and others about defending Adrian Love. And so Adrian's coming in and out of the courtroom. It seems as though they're kind of having her now take a back seat. I recently posted on X how disrespectful again it is to the jurors. Like, no one else, the jurors don't get to sub in and out. They don't get to like have somebody go there for the day when they don't feel like working or being there all day, having to listen to this. The fact that the state is calling in other attorneys and taking other attorneys off, it's just making a mess of the case and is disrespectful to the time that every defense attorney, every defendant, and every juror and the judge have to spend in that courtroom. It's like they have infinite amount of resources. They'll put and how many attorneys does it take to lie and try a really crappy case? And that's what they're doing. So I think you're going to see Adam Abadi there more often. I mean, both of their styles and attitudes are concerning to me. as it relates to ethics and prosecution.
So we're talking about the deputy DA Sprinkle being a witness. And by the way, you can cross-examine any witness on bias, right? And one of the questions I would always want to ask, or the points I would make in front of the jury, is that this witness is being paid by the same people that are paying the prosecutors that are the lawyers on the case. And they all answer to the same boss, right? Whose name, by the way, is Ms. Willis, whose name is on the indictment. So it's just like just too close, right? It takes away some of the objectivity. But to that point, Ashley Merchant chimed in on this as well. She says she thinks the response should be that the defense should be able to call Paul Howard to testify as to why he never brought those charges. For those of you who don't know, Paul Howard was the predecessor district attorney who Fannie Willis beat 4 years ago in the election of 2020. And he, as I understand it, Rachel, you may know more than me about this, but he had elected not to bring these charges because he just felt that it was not something that could be proven. So I think Ashley makes a great point. If you can bring other, prosecutors who work for Willis to say, this is why we've got a strong case and you should convict these people, maybe bring in the prior prosecutor to say why he didn't.
I think that that'd be a good idea. I mean, he was the district attorney from, definitely from 2014 until 2020. So those were several years. I had been wondering the whole time. I mean, that what's really offensive to me about this RICO prosecution, this YSL prosecution, is that we've got shootings back and forth as they're alleging them, that there's all this gun violence. People are dying. People are being injured. And instead of trying to work with these individuals and the people that they do know were involved to try to curb gun violence and save lives, I guess what Fannie Willis was doing, hoping that she would get elected, is, I guess, stack up as many cases as they could so they could throw it all into one big case, all this time, almost 10 years later. Meanwhile, people were dying because they weren't handling the cases at appropriate times. So I would have much rather, so Paul Howard would be a great witness. I'd like to know, he was aware of what was going on. He was aware of the investigations that they were pursuing in 2015. Why weren't they just individually handling each case? All right. So this is a good point that before we get into some of the other stuff I want to talk about, Adam Abadi, he's another, I guess, deputy DA. He's one of the senior management there. He's also testified as a witness, right? And he's handling the probation revocation that we're about to talk about. So if he's been the rule is clear. You can't be a lawyer and a witness in the same case, but yet here we are. So, I just don't understand, as Creed M points out, that, that seems to go against the rules of professional conduct. Yes. And again, their office doesn't really seem to care or understand the rules of professional conduct. It seems very inappropriate to have somebody who's been a witness on the stand before the jury to now have him sitting in the position as an attorney handling the case. I mean, a defense attorney couldn't do that. And I've actually been on a case, which was it was a quasi-civil case because it was a competency trial, where there was another attorney with me who sat with me at the table with our client, who eventually passed away. It's a Shane Kendall case. This other attorney sat with me at the table, didn't handle any of the witnesses or anything, but did sit with us and was also a witness on the stand, but he was not allowed to participate in the trial for that exact reason. We understood the rules. But I don't know if we're getting into the whole Adam Abadi thing today, where he's actually been reprimanded by the Supreme Court of Georgia. Look, Ashley mentioned this on X the other day, and so you mentioned it now. So let's just get into that. Because there was this whole thing about somebody may have alleged that Ashley was lying about some of this because she represents a co-defendant that also has an immunity deal, and so Ashley posted on X that he may have been reprimanded. So what do you know about that? What I know is that there was a case, I think it was decided in 2021, where Adam Abadi had approached a witness claiming they'd get out of jail if they'd testify. Whatever had happened between him and this witness, along with other issues, Brady violations that happened in that case, the trial court actually granted a motion for new trial, which was appealed by the state, and the Supreme Court issued a decision and specifically called out Adam Abadi for his lack of candor and misbehavior. And when we talk about what happened to this probation revocation in a bit, we can talk about it. But the idea is that it's very rare for an attorney to be personally named in a court decision, especially kind of in a reprimanding sort of way. But per usual, a public reprimand or his name in a case, I think it was Thomas versus State, his name being associated with the case, and it's one in hundreds of cases that get published a year. There were no teeth to the consequences. It was just like publicly embarrassing, if you can be embarrassed, which I don't believe that he feels like he can. So there were no real consequences for his behavior, but it is for defense attorneys. I mean, we know that happened. But you would think that after you've been reprimanded for that at least your boss, whoever your supervisor is, would want to ensure that you don't do things like that again. But it appears in this case, the YSL case, as though very similar things are reoccurring.
So Nick raises this point, and thank you for the super chat, Nick. Appreciate it very much. By the way, that's what helps us continue to bring new and better content. So it's much appreciated, that kind of support. He says, sorry he missed this, but to be able to just put another gang expert in after Dennis was yeeted. So it says, who can testify to the exact same things Dennis, then what is the actual sanction? So before we get into the answer of this question, I know you can answer it, Rachel, but before we get into that, what I want to do is I want to go back and let's just share this for context. Let's just show why Doug Weinstein was so upset. I think it relates to this same detective, right, Rachel?
Right.
Your Honor, this one you cannot fix.
By the way, this is courtroom audio is a little low, so maybe turn up your volume as best you can, and then turn it back down.
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that, and I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their intention.
Nonetheless, it happened. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right.
Thank you.
All right, so that was Doug was pushing for a mistrial. Rachel, let me just say, all right, so for anybody who doesn't know, you can't talk about when a person's on trial in a criminal case, you can't talk about what we call just general bad character, to include the fact that somebody may or may not have ever been in jail or in prison or have a criminal record. So, Rachel, what happened to set up this motion by Doug for a mistrial?
Well, Detective Dennis explained that that DeMonte Kendrick actually had been in prison, which you're not supposed to do. In the same way that there's a reason that the criminal defendants are permitted to wear street clothes during a trial, because even if they are incarcerated, it can have a negative effect for the purposes of the jury and their decision to have them believe that the criminal defendant is actually incarcerated and unable to be released on bond. That would make them seem more dangerous. So Detective Dennis, who has been around for a minute, I had a case with him in 2017 where he pulled similar garbage. It's in bad faith for him to say anything about any of the criminal defendants and any history of their incarceration. What saved the state here, ultimately, is that the judge found that because there is a count of the indictment against Kendrick for, I think, possession of a firearm by a convicted felon, the judge basically found that because he's a convicted felon, the jury would already kind of know that he had been to prison, which isn't necessarily.
I think.
Sorry, I didn't mean to go.
No, keep going. No, keep going. That's a good time.
This is the sound you were referring to. So let's just check it out.
All right. I think I am finding that this was not intentionally elicited on the part of the state. However, I also am finding that this witness, as a law enforcement officer, should have known better than to make any mention of it. It is, however, significant that one of the charges against Mr. Kendrick in this indictment is that he is a convicted felon. Were it not for that, I would grant the mistrial motion. But given that this jury already knows that he's been convicted and is a convicted felon anyway, even without this testimony, I don't think that a mistrial is warranted. I am, however, going to give a curative instruction and as a sanction for this having occurred, that's the end of the testimony from this witness. There's going to be no more testimony from him. So he's done.
All right. So Rachel, she ended it. She ended it for Dennis. No more Dennis. Does that mean no cross-examination of Dennis? And if so, does that mean his entire testimony is stricken?
Well, I think, yes. I think what she's saying is no cross-examination of Detective Dennis, and that she is going to strike all of his testimony, except what does that mean? She's going to provide a curative instruction to the jury. I love to talk about this. There is no empirical evidence that an instruction to the jury to disregard certain things that have been said throughout the trial, that there's that is a cure to the taint that it has on the trial. There is no way that these jurors are just going to forget or be able to put aside what they've heard. This is, again, not Detective Dennis's first time on the stand. So here he is again. And now it's going to negatively affect the defense because they can't cross-examine him. And then we now know that the next day they just called another gang expert to basically repeat everything that Detective Dennis had said. So whatever she said, what did she call it? Some kind of, what she called a reprimand, or she called it that she was going to do a punitive something. It didn't have any effect, again, as usual, on the state or the state's case to have his testimony stricken from the record because the jurors heard it. And it wasn't.
So the rule is, right, let's break this down into some smaller pieces. The rule is, let's just say somebody testifies on direct examination, and then let's say they don't testify, or let's say they take the fifth on every question on cross. So you're denied the right, which is an absolute right. It's a constitutional right, actually, in the U.S. Constitution and the state Constitution, to confront or cross-examine your witnesses. So if you don't get the benefit of cross-examination, then everything they say on direct examination is out. But the problem is
It's in.
Ring the bell. How do you take the skunk out of the jury box, if you will, and get them to actually ignore it? So judges, they like to do something called a curative instruction where they say, thou shalt disregard what you just heard. Well, I don't know how you do that, because it's once it's in your head, it's in your head. You can't unhear it.
It's honestly, it's ridiculous to say, and they've done that several times now when the state has purposefully or accidentally elicited testimony from witnesses that's inappropriate and not for the jury's consideration. And they just keep saying, we'll just strike it. Again, on appeal, this would be overturned anyways, in my opinion. This case is such, there are so many errors already.
Well, Juror 403, Free Me, thank you for the super chat, asks, do you think Whitaker is checking off the boxes on her list to dismiss with prejudice? Rachel, you think that's what's going on, or what do you think?
No. Again, I want to be a hopeful person, but no, she is a former prosecutor, as I'm sure we're going to get to shortly. Some of her behavior this past week has demonstrated to me she thinks these guys are guilty. I mean, I think she's giving them, in some ways, a more fair trial than Glanville was giving them, but she was in the DA's office up until, I think, 2020. So she knows what was going on in that office. She knows what some of these investigations, were, and she seems to have an opinion that it should go forward, and she wants to see it through to a jury verdict. And I don't believe that she has the personal, I don't know what the right word is. Again, I'm pregnant. My pregnancy brain is getting to me, but it's like she doesn't have there's something about, like, she doesn't have a spine. Like, she's not willing to. There are some judges in Fulton County that, for better or worse, would be very happy to dismiss this case with prejudice at the first opportunity that the state does something like this. She is a career prosecutor who's now a judge. So she's going to find any way for the state to stay in the game. I don't think that they purposely did this. They didn't purposely do that. They lack duty of candor to the court. Boo-hoo. She does nothing about it. So I think she's trying to move this case through and hoping that there's a conviction, seemingly, which is messed up. That's just my own opinion. I don't know. I'm not in her head, but I have no hope.
So there's, this whole thing with the gang expert. Who did they bring next? And wasn't that just cumulative of what the jury was told to disregard?
Some other gang expert, and yes, it's cumulative, but I guess it's not if they were told to disregard the first batch of, but again, it's not even the first batch. We've already had Gaither. We've already had Dennis. Dennis got back on the stand. Then we've got Sprinkle, and then we've got this other lady, and they're just telling them all these. I think I sent you. There's one part where Detective Dennis, in his testimony that's now not permitted, the judge is asking him before the jury comes in, like, what basis he has for being able to decipher the meaning of rap lyrics. And he's talking about how he's a rap fan and his life and seeing movies. It's like, well, me too. I mean, what basis does he have to tell me what Young Thug meant when he rapped, lyrics? Like, and the basis is that he's a rap fan.
All right. It's disgusting. All right. Well, let's get into the next big thing that happened this week. And in that regard.
All right. Well, I find there to have been a violation as alleged. And again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that.
All right. So we now have Mr. Sledge found to be in violation of his probation because he didn't testify the way the state maybe expected or wanted him to, right? So what's going on?
Okay. So again, I I try not to get worked up. I'm a pregnant person that I guess they tell me not to get worked up. It's just in my nature. And this just drives me bonkers. Okay. So as part of a plea deal that he took to be released from custody, he was facing like 200 plus years in prison. He got a 30-year probation sentence after spending like 22 months in Fulton County Jail. We all know what the condition of Fulton County Jail was, especially back in 2022, where people were literally dropping like flies, dying from bed bug infestations. We have it's just a horrible place to be, third world horror. Okay, he had an attorney that worked out a deal, and as part of the deal, in addition to just agreeing to testify truthfully at the YSL trial, there were specific factual statements that he agreed that he would testify to if and when he was called as a witness at this trial. Some of those statements were, things like, YSL's a gang, blah, 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 blah. When he got on the stand recently and did not testify to those things, the state filed a motion to revoke his probation. So then he still had.
Before you go on, I don't mean to
No, you're good.
Be rude and interruption, but I want to because I want you to finish that thought. But I want to just mention to anybody who may not really understand. So under Georgia law, when you're put on probation, there are certain things that are called statutory requirements of probation. They're common sense things like don't break the law, don't get intoxicated. You got to show up to probation when you're told to, and you allow your probation officer to visit you at home, things like that. They're all statutory. Then there are other things that are called special conditions. And it might be like if it's a DUI case, maybe you're ordered to go get a substance abuse evaluation to see if you've got a substance abuse problem. Or maybe it's you're ordered to pay restitution if you've been convicted of shoplifting or something like that. So those are what we call special conditions. So if someone gets rearrested and charged with a new crime, well, that's one thing. But if it's simply a violation of one of these other rules, okay, that has nothing to do with getting rearrested, we call that a technical violation. Now, what does a prosecutor have to prove? Well, this is not a trial by jury, so it's not proof beyond a reasonable doubt. You do have due process. They file a petition to revoke your probation where they've got to put you on notice of what they say you did to violate your probation. But there's no jury, it's only the judge, and they have to prove it to the judge's satisfaction by what's called a preponderance of the evidence. So let's just say you want a full hearing on this. You can hash it out. You can say, no, we didn't violate probation and here's why. Or you could say, okay, we did violate probation. We agree to that, but we want you to be lenient on us, in which case you would call that what we call a disposition hearing, where you just let the judge decide what the penalty is. But it's very, very, very easy compared to a new criminal charge to prove that somebody has violated probation. So it's a miniature trial, but we saw this whole thing unfold in an hour. Rachel, did they contest that he violated probation at all? Or did they say, look, judge, you heard the testimony, you get to decide?
So I feel like his attorney was pretty deferential to the judge. Derek Wright, didn't really argue to the court. He didn't argue to the court that his client, didn't violate, but he was kind of suggesting that the violations, the lack of truthful testimony was actually the result of Adrian Love changing up some of the language in the factual parts of the plea deal. And yeah, I don't like to trash another attorney. I know Mr. Wright has had some health issues. I know that his client at the time that they took the plea wanted out of jail. And I think that they did what they needed to do to get him out. Obviously, it'd be a lot better to negotiate a plea involving 30 years probation where you didn't have to agree to the factual statements that very clearly his client didn't write those facts, that Adrian Love wrote the facts and then told him that if he wanted to get out, he would have to say those things. In those moments where you're taking a plea and all you want to do is get out because survival is more important than anything, it's no surprise to me that he agreed to the plea and agreed to all the factual statements. Ultimately, when he got on the stand, he was told to testify truthfully, and what he said on the stand was not the same as what Adrian Love had typed out for him.
So they didn't actually. So it's almost like they just incorporated the testimony from the trial, and they said, "Okay, here's the plea deal the judge had in front of her. She could see his initials on it, and she compared that to what she heard when he testified." And so that was essentially the trial. That she was comparing what she saw in the documents to what she heard in court, and so she found that there was a probation violation, which is, we just heard that sound. So let's take a look at what Mr. Wright had to say about what penalty, if any, should be extracted.
To some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
All right, so that's what you call that's essentially the sentencing phase of this hearing, right? Where each side gets to say what they want. You heard Adam Abadi say, Judge, we're going to leave it up to you. And essentially, Mr. Wright is arguing for something less than incarceration. Your thoughts, Rachel, before we get into what the judge did?
Well, just a few things. I mean, it was very clear from the attitude of the judge that she believed that he violated. And I think she at some point said that she actually does believe that it's more akin to perjury, which is another substantive charge. When you're trying, the probation officer didn't give a recommendation to the court as to what should happen. The state didn't give a recommendation to the court as to what should happen. And his lawyer didn't give another option other than just saying it needs to have more teeth. I mean, 30 years with the ability to be revoked. I mean, that's teeth. That's teeth. And so I think, asking for something a little bit more specific, more restorative, more productive as a form of punishment, talking about taxpayer dollars, talking about the basis, for the plea, the reasons that he advised his client to take the plea, and maybe fallen on his sword a little bit more that, he didn't think that this would ever come to him having to testify. And so, he may have advised his client that to kind of ignore the factual statements that he was agreeing to and just do it because he needed to get out. And he was basically in duress in the jail. And so it's not clear whether he was actually lying on the stand when he got on the stand in the YSL trial, that he didn't initially even agree with the factual statements that Adrian had written out. But, I just think in general, I mean, knowing that he had not committed any new substantive violations, that's very important. I do think that there's ways other than prison or incarceration to handle this, but you have to provide the court with a different plan if you expect her to do anything other than what she, as a former prosecutor, is very comfortable doing. And as
let's take a look at that. Let's see what she did.
Let's see what she did.
Technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a nonviolent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which.
So let me pause her for a minute. She's about to punish him for not having a proper regard for the judicial system. But what have we seen with these prosecutors now for, forever, since the beginning of this case?
She has admonished the state on several occasions for their lack of candor, for their lack of preparedness, for their lack of taking seriously these judicial proceedings. And then it's almost as though, because she doesn't feel like she could put them in jail for contempt, even though I would argue.
Yeah, she can.
I would argue she can, exactly. But it's like apparently inappropriate because they're professionals who should know better. But he's somebody who was just trying to get out of jail. That she's going to put all of her frustration with nobody taking these these proceedings seriously, that she's going to put it on this gentleman who actually has a lot to lose. There's more than, and she's like, well, he took the plea, he agreed to it. There's just so much more that goes into a decision to take a plea. There's so much more that went into how he testified on the stand. What if it was the truth? What if, and so to punish him the way that she's about to punish him makes my blood boil, and it makes me sick because, again, Adam Abadi, Adrian Love, some of these other individuals on the prosecution team, they took ethics. They, took an oath to abide by rules of professional conduct that go against and contradict their behavior in court. The judge has been very clear about what she sees them doing. And she actually says, and sometimes she thinks that it's intentional, and and there's no punishment for them. But let's see. Here we go.
An oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back.
Disgusting.
But we've got to.
Look, I mean, I'm going to finish this video, but I was kind of taken aback by, she says, I hope this doesn't set you back. 5 years. His underlying charge, this is in the state prison system. Okay. His underlying charges, I understand, are gang related charges, which are serious, but I point that out because on the parole grid, I'm sure that, I haven't done the math, I haven't looked at the parole grid, but I would imagine that he can probably plan on spending most, if not all, of that 5 years, in prison. He may get paroled out a little early, but I think by and large, for the majority of it, he's going to be there.
Take seriously.
Yeah, well, because he's really quick, because he's there.
What's that?
I can't stand her. I can't stand it. But no. So on the parole grid, because it's a probation revocation, and that's the basis for him going back to prison. It's actually, I think, considered like a level 7, which the highest one is, I believe, a level 8, and so it's like 36 to 56 months or something like that. So he's looking at like 3 more years in custody. To say to any human being or any dog, even if you were to say to my dog that he had to go spend, 5 years, you hope it doesn't set him back.
Yeah.
What is wrong with you?
Odd thing to say.
Do you not value his life? And these prosecutors on the bench, but also in real life, are so desensitized to what 5 years, 5 days, they could get. It just shows how little they value lives that they have deemed less important than their own. And there is a fallout to this. I mean, we have taxpayer dollars for 5 years. He has kids. He has grandkids. I usually don't like, throwing your kids into things and saying, well, because I have a child, you shouldn't put me in jail or whatever. But 5 years, I mean, that's that's 3rd grade to 8th grade.
So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
All right, and there it is. So 5 years, he's off. I mean, look, probation has to mean something. I get it. The rules have to mean something. If you're ordered by a court to do something, and that's what a sentence is, it has to mean something. But look, I mean, Rachel, you can speak to this maybe better than I can, but it's not like what he was going to be expected to testify. It's not like that was all like crystal clear. And I think there were some issues related to the, what's it called? The proffer agreement and all that. Am I right?
Yes. It was shaped by Adrienne Love, who this judge has admittedly that she knows that Adrienne Love plays games, isn't honest, and that really the purpose of the plea and the facts were for the state's benefit if and when they were going to try this YSL trial. And so you have to know that it's not akin to perjury. My thing is charge him with perjury then. And then let's actually have
a trial.
Yeah, let's have a trial. Let's be fair about this. I also think that the state got in what the original proffer agreement was, and all of those facts that Adrienne Love drafted, that all came in at the trial. I could think of a million other forms of what I would consider more creative, productive punishment than 5 years in prison. It's just so disgusting. Again, it's not taking into any consideration the duress that he was under when he decided to take the plea so that he could get out. And the fact that the state was like, we're not going to make a recommendation and we're going to let the court decide. Well, the court is the one deciding, but the fact that you're just going to sit back and know that because you have a judge who's a former prosecutor who, like y'all, doesn't understand time, know that she's going to do what she's going to do. It's just unethical at this point. I realize that he made an agreement, but there's lots of other individuals who I believe made, more serious agreements, took more serious oaths than somebody who was trying to get out of jail. And that's Adrienne and Adam Abadi, and there is no punishment for them. And I cannot handle it.
Well, the question that Blurry Lights posed, thank you for the super chat, by the way, is why didn't Wright negotiate immunity for Mr. Sledge? Wu Dee's attorney did. Well, I don't know that there wasn't an effort. Maybe there was an effort but you can't make prosecutors do something if they just are not willing to do it. But what you can do is you can negotiate a plea deal that gets your client released on certain conditions. And sometimes the prosecutors they might say, look, we're not going to agree to anything that gets your client out of jail unless the plea deal includes, this particular testimony. And that's what happened here. So I don't want to second guess what Mr. Wright may or may not have done, because what he did do is he negotiated something that got his client out of jail. And so maybe that was what seemed to fit the circumstances and the facts of the case better at the time. But it's a good point. This is off topic, but Michael, I wanted to go ahead and point it out I want to make sure I mention these folks who, with the super chats, because I want to say thank you. Michael Lawless points out that he can't believe no jurors took the chance to leave the trial when Whitaker asked if they could overlook. I guess maybe is he talking about Sprinkle's testimony, Rachel?
I don't know when she last asked the jurors whether they could overlook certain things, but I mean, I was surprised too, because if you wanted out, you could get out. I think all these jurors at this point are probably hoping that they can maybe get a book deal after the fact, and they should get some sort of compensation beyond the, was it $25 a day that they're getting for having to sit through all this. I don't know why. So, I mean, I guess they're in it this long, they might as well stick around, but who knows how long it's going to last. We were saying, I think we had previously said, I'm due at the beginning of February. I don't think they're going to be done by February.
No, in heavens no. Not unless there's a mistrial or something that surprises us. Anna Burnham, New York appellate attorney, says, it asks if there's an appeal, do we think that the Georgia appellate court will feel about, how will they feel about the state's use of RICO and abuse of the judiciary? You know, and that's an excellent question that I honestly don't have a great answer for, except to say that I think that we got to get through the trial first. Okay. And can you imagine how long the appeal is going to take just to get it ready to be filed? Because if this trial goes on for years, okay, Anna, if you're an appellate attorney, I'm sure you know this, but everybody else probably doesn't appreciate. They've got to get all of the exhibits, all of the testimony. All the testimony's got to be transcribed. And then whoever the appellate lawyers are, and it won't be the same ones in the courtroom. It's going to be a different lawyer that represents anybody that gets convicted. They've got to read through all of the transcripts to look for what legal issues they might want to appeal. And then they've got to brief those things. They got to research it, and they got to put it all together in an appellate brief. And none of that stuff can even be sent off to the Court of Appeals until the official transcript's prepared, until what's called the record of the case, which is everything that the clerk's office has received into evidence. I just can't even, it's a breathtaking scope of some, I just can't even get my head wrapped around how big, and just I think it's just maybe impossible to even get this case up on appeal within a decade. It blows my mind.
I would agree with that. And I think what's also kind of messed up, back to tax dollars, is that you have the right to an appointed attorney on appeal as well. So, I mean, these guys are going to be, given how much they're probably paying for their trial attorneys, it's not as though they have endless money to be paying an attorney to take on a case like this. And so they're going to end up probably needing appointed counsel, and that's coming back to the taxpayer dollars. So you're going to have 6 appellate attorneys reading, this years-long transcript and working on the appeal. So no, I think by the time, if and when it ever gets to a higher court, there's going to be some admonishment. But I don't want admonishment. I want punishment.
So thank you, Transplanted Texan, for bringing to our attention. The chat was clarifying that, yes, it was reference to Dennis's testimony about them being able to ignore it. Yeah. I just, there's so many things about this case that I can't really get my head wrapped around. But like Dee Dee points out that, trauma bonding is probably the reason the jurors are still there. Because look, if I were on this, if I had a way off of it, I'd take it. Just any old way. I would absolutely take it. By the way, Rachel, talk to me about whether or not you can appeal two things. Can you appeal from a plea in Georgia? And then can you appeal from a probation revocation?
I'm sure, yes. I believe that there's ways to do that. However, from what I witnessed, I don't think that there's any basis to appeal the probation revocation, because technically he did violate, and technically the judge was within her discretion in the manner in which she sentenced him. which is sick and not the answer that anybody wants and not the answer that I want. And
So
I see another question about whether he could have taken his plea back. If he was going to take his plea back, they would have put him back in jail. So again,
you can appeal. Like if you feel like your lawyer was ineffective, you can't really. There's not much you can appeal from on a plea. But if you think your rights are violated during the plea process, you've got 4 years to do what's called a habeas appeal, which might include like an ineffective assistance of counsel claim, and you can technically appeal from the findings of the judge in the revocation hearing. But it's an exercise almost in futility because the judge has so much discretion, and particularly like when if she revokes 5 years, and it's technically something that was within her discretionary power to do, the Court of Appeals is not going to upset that.
Yeah, and also like it wasn't particularly ineffective as much as the Derek Wright didn't outwardly fight passionately for his client. He wasn't ineffective in getting him that plea, because that plea got him out of like 200 plus years that he was facing in prison, and he got a probation sentence. So it's a tough sell as well if you were trying to make that argument.
So Tasha's pointing out, as a healthcare provider, she says it's unconscionable that they forced him to testify after being hospitalized with sickle cell anemia and pneumonia. And so that's actually a really good point. Do you think the judge just ignored all that, or did that factor in? It seems to me like maybe it wasn't even discussed at the revocation.
Yeah, I think she kind of forgot, nor do I think she cares about his health. God forbid it sets him back.
Thank you for the comment. Thank you for the super chat, Tasha. It's
so
all
sad.
It's all the circumstances surrounding his testimony would have been relevant. Rachel, this was a little bit off the topic, but City Girl says watch Sprinkle September 30th during Cross by Adams, and then also watch Love's Behavior during Cross by Adams on the 30th. And I don't know what
I look forward to watching that.
Reference there, but I know that I wanted to bring this to your attention because I know you like to bulldog these things and maybe go back and see what's going on. And those of you out there who are watching now, maybe you can go back and
so they're saying really quick, the chat's saying that it wasn't Mounk Tounk and that it wasn't Sledge, that it was Zachary. That it wasn't and sickle cell. But at the same time, what I can say, health issues in jail are not going to be addressed or in prison the way that they would be when you have the right to, go to whatever hospital you want and be under the care of whatever physician that you want. So we can talk about the fact that by putting him in prison for 5 years for not testifying truthfully, we know we have other witnesses coming up who've made similar deals with the state, and I feel that the judge has now helped and emboldened, as Ashley Merchant and I discussed this, that it has emboldened the state to push individuals to testify in the way that they want them to testify, or else face prison time, which is so dangerous because, again, the truth should matter more than anything, not the state's crafting of a story.
Right. Yeah, and so this is exactly the question that David Jack is like, how does this not cause future problems with future witnesses? And I think that was what they wanted to send the message to other witnesses that might have had these deals. I think it was exactly the whole point. And that was probably also the point in the judge giving him 5 years, is to make an example out of it.
Yeah, to make examples out of people with years of their life, it's just inappropriate, and it's an abuse of power. And again, you can provide, I would have him do like 40 hours of community service every 2 weeks. Have him do something from home that can be productive. There is no need to send him to prison for this. And it's hard to witness. And I also would believe that Derek Wright probably had conversations with Adrienne Love where she made it seem like he would probably never have to testify. And so the fact that it came to this, and then the state did what they did, and that instead of being remotely empathetic, she says she's empathetic to his situation, but then she sentences him to 5 years in prison. 5 years, it's like 5 days. You know, 5 days would be a lot. 5 hours would be a lot. 5 years, like it's no big deal. It's just somebody's life that you don't care about.
So Chrissy asked the question, did they plan to time this filing so Whitaker would get this revocation hearing? I'm not exactly 100% sure what Chrissy's asking, but she says she imagines it was calculated given what we've seen from the DA's office this far. I don't think that they had to wait until after the testimony occurred.
I don't think Glanville would have done anything different. I'm not sure
No.
I'm not sure which judge heard it originally. I think it probably should. I wish it went to a different judge. I wish she would have recused herself on it. I mean, she seemed upset of the way that he testified and took it out on him.
Yeah, I think that's, I don't know that, look, I don't put it past anybody to do anything that's calculated. And in a lot of ways, trial practice has a lot to do with calculating things. But in this case, I think it's probably just sort of just a happenstance. But anyway, thank you so much for the question and for the super chat as well. Rachel, what's going on now? What can we expect to happen coming up this week? Do you know?
No, but I'll be there tomorrow. So maybe next week.
Oh, you're going to be there tomorrow?
Yeah, I'm going to stop in. I have court myself in that courthouse. So I'll stop in for a few minutes and see what's going on. But I'm sure it's just more madness. You know, this judge, you can tell she's getting frustrated, but then she's taking it out on the wrong people. And then she's kind of harnessing herself, like, you know, she'll be mean to Adrian as she should be. And then she'll kind of pull back and then do things that are excessively nice for the state. She clearly likes Adam more than Adrian. And that's part of the reason why. Oh, thank you, Misty. I get so upset about this. I mean, I was thinking about the fact that Sledge was going to have to go back to Rice Street. It was the safer option for him because we're not even considering the fact that this is on national television and that he could be considered a snitch if he were to agree to some of the things that the state wrote out for him and how that could affect him and his children and their safety. That was it's a whole nother part of how he chose to testify. And so the fact that nobody cared or considered that was part of what was going on, it's just madness. I still don't know. I still don't see the evidence against these individuals. I don't understand why, where is the actual evidence? Where are the facts that prove their case? I'm at a loss. I'll let you know if anything happens tomorrow. I'll try to stay
real quick before we let you go, because I know I've kept you 2 hours and you're eating for 2, so I don't want to keep you from dinner.
And I haven't eaten in 2 hours. I'm so proud of myself. It's really crazy.
All right, so well, I mean, we might be pushing our luck then, but anyway, real quick. So tell me about what it's like down there. Does Whitaker still have all the crazy security requirements in place that Glanville had, or has that changed any?
I'd say it got worse.
Oh, really? Explain.
Yes. So, I used to be able to go into the courtroom as an attorney, I'd bring my phone in, no problem. I'd be able to go chat with some of the defense attorneys and the defendants while they were seated there waiting for court. I would say that, and there was more space for, I think she calls us the general public. Like, even if you're an attorney now, you have to put your phone in a locked container, like if you're going to a comedy show or a concert that they don't want people filming. So you cannot have access to your phone while you're in the courtroom. You're not allowed to look or interact with any of the defendants. You're only on the back row of the farthest side of the courtroom, so you cannot see the jurors. And it's a much tighter ship in a way that I think is really disrespectful to attorneys. For some reason, the middle rows, the state is allowed to have their investigators or whoever they feel like they want to bring in sit there. They can look at the jurors, but the general public has to stay as far away from the defendants and from the jury. They put us in the corner. So that's what's happened. And the judge just doesn't really seem to have any tolerance at all for the fact that it is a public courtroom. And yeah, she has been very disrespectful to the media. I mean, it's it does not feel like an open courtroom where people have the right to be present and view what's going on. Also, just the pace of the trial with no cell phone to distract yourself. These jurors have got to be falling asleep because on a day-to-day basis, it's just so boring. So thank God for like Doug Weinstein for waking everyone up every once in a while. But those are things that are happening off the record, where the jurors don't even know what's going on. So I have to believe that I hope they're, considering the reality of what's happening.
I got one more super chat question that I want to address to you before I know you got to go. What do you think will come about with a bar complaint? I know what you're going to say, but I'll let you say it.
She should walk the plank.
Okay. What will happen? Not what Rachel.
I don't know. I think she'll probably get an admonishment, and again, maybe have to take a class. She should be disbarred. She should have been disbarred before this trial. It is so hard to reach prosecutors and for there to be any level of punishment. So I'm not hopeful that I think it'll be business as usual for her. She'll defend herself. They might give her a slap on the wrist and move on. But she should. What would I like to see happen? Again, walk the plank and get out of here.
And I said this will be the last one for you because I know you got. So Steele's all right. So the contempt is not really a hearing; it's the appeal, right? That's coming up. Is it this week in the Court of Appeals? Because I know some of the members of the Georgia Association of Criminal Defense Lawyers are involved in that. Is that coming up this week already?
I do not know, but talk about admonishment. I mean, I think that the higher courts are going to be horrified. And demonstrate that in whatever decision gets written about this, the fact that they were going to try to hold Steele in contempt for not providing the name of the person that told him about the completely inappropriate ex parte communication. Like, whoa. We'll see.
Michael, Michael, what I can tell you, I don't know. It's going to be a panel of judges. If it's at the Court of Appeals, I don't know which panel it's going to have, but I do think that Steele is going to prevail at the Court of Appeals. So hopefully that gives you some answer. I wish I had a better one for you, buddy, but thank you very much for the question. Rachel, thank you. I've got a couple of questions of things I'm going to say, but we're going to let Rachel go enjoy the rest of her Sunday.
Until next time.
A big inside the
Love
law
you all.
of applause and say goodnight to Rachel. Good night, Rachel. All right. So look, Rachel just has so much that she would love to say, and I like giving her every chance to say it when I can. But I wanted to point out those of you who have asked super chats I've tried to address all of those and then some, as well as keep the conversation going. Jeffrey Jordan asks, do I know when Ashley is going to finish the hearing? Jeffrey, I think that you are probably referring to the open records case. And I know that it was continued. And if I had known this question was going to come up, I would have an answer for you because I've been told what the date was. But as we right here live, I just don't remember. But I probably bet someone in the chat can answer you. And by the way, my great moderator, Transplanted Texan, tells me that oral argument for Steele's contempt has been scheduled for October 22nd, 2 days from now, at 10 a.m. Colette Steele, Ashley Merchant, and others have filed a brief. So that's going to be the 22nd. And then we have, and Texan also tells me she posts a link to the live stream from Judge Krause's courtroom. But if you go there or you just kind of check out the schedule on the calendar, you'll be able to figure that out. I don't know exactly when that was continued to, but thank you very much, Texan, for the help, and thank you for the questions, and of course, thank you for the super chats. And before we say goodnight, I want to ask a favor. If you haven't subscribed here, I would like you to consider doing that because before today, we were closing in on 50,000 and subscribers, that is. And maybe I'm over that by now, but it was just a few hundred short. And I would like to just ask you, if you like this content, if you want to know what the real justice system is about, not what you just see and hear on TV, but how it really works in the real world, if you find any kind of value in this at all, consider subscribing. It doesn't cost you anything, but it also helps other people to find this content who might be interested in it. So I just wanted to mention that to all of you. And I wanted to answer this question earlier. I wanted to answer this question on X, and thank you, Melissa, for bringing it up. How can the state appeal a case? So the state cannot appeal if they lose a trial. If there's an acquittal, that's it. It's over. If it's a directed verdict of acquittal, they can't appeal. They can appeal certain types of rulings. Let's say you file a motion to throw out evidence before a trial starts, and the judge rules that the evidence can be thrown out. The state might be able to appeal that. If the judge dismisses an indictment pre-trial, they might be able to appeal and to get the indictment reinstated. But there's very few things like these rulings on objections and all this. In the event of a conviction, it will be the defense that files any appeal, and it will raise it might raise that as an issue as to why the case might need to be reversed. But in the event of an acquittal, the state can't appeal at all. So none of the rulings, evidentiary rulings that go against these prosecutors can ever be appealed by the prosecutors. So, but thank you very much. It's a common question, something we get all the time. But generally speaking, there's very, very limited appeals that the state can take. They certainly cannot take one in the event of an acquittal. And evidentiary rulings that go against them at trial, that's just kind of tough for them, because there's really nothing else they're going to be able to do about it. So anyway, but thank you very much for the question, and thank you to all of you for being here. And I just want to leave you with one thought, and I just maybe a bit of advice. I want to make sure that none of you wind up as this guy.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang in.
All right, guys, we'll have to leave it right there. And until next time, thanks for watching, and I'll see you next time here inside the law.